Intellectually curious and socially engaged individuals are drawn to law because at its heart the discipline is concerned with almost every prominent social, economic, and political issue. Although all areas of law intersect with societal problems, tax law straddles the full universe of issues more than most, addressing issues from the relatively straightforward design of employee compensation packages to the incentives provided in the most complex corporate reorganizations. I want to spend a bit of time setting the frame for some of the work being undertaken by my tax law colleagues in pursuit of international tax justice over the course of the next 2 days, hopefully in a way that will inspire the graduate students in the room, and I'll say a word or two about a paper I'm working on in the vein of that scholarship. In a move that can only be described as genius, Alison Christians has brought into the room for the next 2 days a number of tax scholars who are, I think, working at the boundaries of one of the most pressing political and economic problems, the widening gap between high and low-income countries. I think this strand of research is perhaps slightly esoteric in the branch of the larger project of the role of tax systems in supporting our human rights aspirations, but it is nevertheless an important strand. Only a few tax scholars were preoccupied by this problem before the millennium. In some ways, that's surprising. Almost from the emergence of tax treaty negotiations in the 1920s and 1930s, low-income countries recognized the importance of appropriately drafted tax treaties in preserving their revenue-raising capacities. The United Nations has had the problem on their ongoing review list since the 1960s. Nevertheless, for a long time, orthodox economic theory suggested that the level of incomes for rich and poor countries would converge. Investment would flow from rich countries, where capital is in abundant supply, and returns are low, to poor countries, where capital is in short supply and returns are higher. The brutal facts of the ongoing inequality between nations would be rendered, would disappear, and yet that theory has been rendered largely laughable by the facts. Low-income countries are, of course, desperate for revenues to provide basic healthcare and education, to construct modern transportation and communication systems, to facilitate food security and access to housing and access to clean water, to increase the productivity of workers, and so on. It seems incongruous, and some might even say immoral, for high-income countries to, on the one hand, admit the case and the pragmatic need for providing aid to low-income countries, but on the other hand, to design their tax systems in a way that makes it impossible for low-income countries to collect tax revenue. Many of the scholars in this room have served to build a school of thought, the main premise of which is that high-income countries have an obligation to design their tax systems in a way that supports the revenue-raising potential of low-income countries. In other words, their scholarship accepts that it is incongruous for high-income countries to, on the one hand, express concern about providing aid to low-income countries, and on the other hand, design their tax systems in ways that constrain the ability of those governments to raise revenue or provide particular social and economic incentives. I had the pleasure of working with Alison in 2008 on a workshop that brought some of those scholars together. The workshop was entitled Tracking Our Fiscal Footprint. I think this cluster of scholars is broadly conceived of then as the fiscal footprint scholars. Their work is designed to reveal, prod, make plain, interrogate, and learn more about the ways in which high-income countries' tax systems are designed, generally deliberately, to make it impossible for low-income countries to use their tax systems to address significant levels of international inequality, and ideally, to effect responsive reform. To illustrate the kind of work being undertaken by scholars interested in this question, good timing, Kathy, we highlight a piece of work by each of 4 people in the room who have actively been building scholarship in this area. One quite unique contribution Alison Christians has made has been to focus on the role of the Organization for Economic Cooperation and Development in setting international tax norms that disadvantage and structurally preclude the engagement of low-income non-OECD countries. The OECD seems an obvious institution worthy of study. Scholars regularly report on the views and positions of the OECD, but have only very rarely delved into the function the OECD plays in international norm setting. Stephen Dean has contributed to the scholarship on the broader question of whether it makes sense for the tax systems of different jurisdictions to move towards greater harmonization as a means of showing up their overall effectiveness. He has made the case for a move he's termed deharmonization, which broadly means moving towards coordination of tax systems instead of harmonization. Michael Noel has contributed to our understanding of the role and function of targeting tax incentives as a way of promoting investments. Specifically, he's written about tax-sparing provisions. Those provisions, in the limited cases where they are used, are included in tax treaties entered into between high and low-income countries. Their purpose is to preserve the low-income country's ability to offer a tax incentive to attract investment. Their use has been controversial, with the OECD ultimately recommending against their inclusion, and some low and middle-income countries lobbying fiercely for their continued importance. Kathy Leahy's work focuses directly on the gendered impact of the taxation of international transactions. While feminist analysis has informed much domestic tax policy analysis, it has been entirely absent from the international tax policy work. Kathy's work in this regard is groundbreaking. She's explored the role that international institutions, directed largely by high-income states, support or undermine gender analysis, undermine the gendered impact of foreign direct investment, and highlighted the redistributive concerns of international tax systems for women. Lynn Latulippe has undertaken extraordinary, careful, empirical work on the design of tax treaties that is badly needed. I would be remiss if I didn't offer a nod to Neil Buchanan and Henry Ordauer, both at this conference. Their work doesn't directly stare into the eye of how high-income countries' tax systems hamstring the ability of low-income countries to raise badly needed revenue and reduce international inequality, but they regularly and enthusiastically participate in discussions of the work of others in this area. This review has left out myriad people who are contributing to this stream of inquiry, from Yari Browner to Karen Brown to Miranda Stewart to Jalia Congrave to Tilly Dagan to Lisa Phillips, Pasquale Pistone, and Anna Dorado, simply to cross 7 countries, and so on. Before turning then to what comes next, let me offer also a word of thanks to Lee Shepard, who as contributing editor at Tax Analyst has often served as an academic companion of sorts. Lee regularly and directly addresses the interaction of tax systems and the effect of that interaction on source states. Her pieces are always timely, mainly succinct, always direct, and generally readable. Sometimes she opens with lengthy discussions of football that are technically fraught, hard to understand, in both terms of art, but if you can get through the football part at the beginning of each article, the rest of it makes international tax law and politics gripping and accessible. Let me say a word or two about a project that I'm working on at the moment, and then I'll conclude. In late 2012, Mongolia canceled its tax treaty with the Netherlands. This was a relatively quiet event for most people in the world, but a major marker for those of us who follow the politics of tax treaty negotiations. The tax treaty between Mongolia and the Netherlands had a 0 withholding tax rate on direct investment into Mongolia. As a result, everyone coming into Mongolia to extract natural resources was effectively able to withdraw the income that they earned from that country without paying tax on the withholding. That treaty cancellation signaled a kind of first crack in some ways into source countries' willingness to resist striking bargains with high-income states to reduce their ability to collect tax revenue. And so the paper I'm working on, and it builds, to the extent that I can follow the tweets from yesterday, actually a bit in the same vein as one of the people who presented in the morning, it appears, makes the claim that tax treaties are, at this stage in our development, unnecessary. And there's 4 parts of the claim in the paper. First, that tax treaties disadvantage source states, often low-income countries. Second, that comprehensive tax treaties are unnecessary for their articulated purposes. Third, and more specifically, that none of the rationale for ceding source basis of taxation makes sense any longer. And fourth, if you're going to cede taxing rights, you should just do it unilaterally. The paper is not novel in the sense that other folks have made that claim over time, but without having had a lot of traction. But at this particular moment, for me, it's interesting because of the active pursuit of the base erosion project. And when you look at the kinds of questions that are being asked as part of that project, none of them strike at this kind of fundamental problem in the design of international tax systems. In fact, if you wanted to eradicate base erosion, one relatively straightforward way to do it would be to get rid of the these overlapping bilateral tax treaties that no longer serve, in my view, an effective purpose. So let me end this brief review of the emerging body of scholarship that seeks to take the tax justice interests of low-income states seriously with a call for graduate students. Michael Keane is right, I think, when he complains in a 2011 piece that there's a persistent flaw in much of this work, that it overgeneralizes. Many of the pieces that those of us working on in this area take for granted that there are high and low-income states. We appreciate, of course, that those categories are too broad to be terribly useful. We know that our general observations may well not hold for any particular country. This body of scholarship needs a lot more work. We need work on the difference that natural resource wealth, country size, proximity to oceans, political instability, colonial history, language, relationship with neighboring countries, and so on have on the ability of low-income countries to raise revenue and use their tax systems as an effective instrument of development and human rights. There is much work to be done in this area. Thanks.